If you are not able to reach agreements on all of the issues in your case, then you will be ordered to come to court hearings. If both sides are representing themselves and there are no attorneys involved in the case, then after the response to the petition is filed, the parties will be ordered to attend an early resolution conference. At an ERC, the parties meet in a conference room with a family law case manager, not a judge, and talk about each of the issues in the case and see if agreements can be reached on those issues. At least 5 days before the ERC, you will be ordered to submit a resolution management statement to the court and the other party. In your statement, you need to identify any agreements you have reached with the other side and what your position is on each of the issues you do not agree on. You can find the resolution management statement form and instructions that tell you how to fill it out and what documents you need to attach to it at any of the court's self-service centers and on the court's website. Information on proposed management statements can be found in your handout. If agreements are reached on all of the issues at the ERC, the family law case manager will put your agreements in writing by drafting a decree of dissolution or a paternity order. After the parties have had a chance to review the document and make any changes they agree to make, the family law case manager will take the decree of dissolution or paternity order to a judicial officer to sign. The judicial officer in most cases will sign the decree or order immediately. Once the decree or order is signed, the case is over. At the end of the ERC, if agreements are reached on some but not all of the issues, the family law case manager will put those agreements in a document for the parties to sign. Once it is signed, the family law case manager sends the document to the judge assigned to that case, so the judge knows what agreements were reached and what those agreements are. Before you leave the early resolution conference, you will also be given the date and time for your next court hearing, which will probably be a resolution management conference in front of your judge. If either or both of you have hired an attorney by the time the response is filed, your first hearing will be in front of a judge and will probably be a resolution management conference. At least 5 days before your resolution management conference, you and your attorney must meet face-to-face with the other side and that side's attorney, unless there is an order in place prohibiting the parties from having contact or there is a significant history of domestic violence between the parties. The purpose of this face-to-face meeting is for the two of you to try and reach agreements on as many issues as possible. In addition, at least 5 days before your resolution management conference, you must prepare and file with the court a resolution management statement. This is where you identify for the judge in writing any agreements you have reached with the other side and what your position is about each of the issues you do not agree on. You can find the resolution management statement form, instructions that tell you how to fill it out, and what documents you need to attach to it at any of the court's self-service centers and on the court's website. For more information on proposed management statements, you can visit the website that is in your handout. Lastly, you need to comply with your disclosure requirements. In every divorce and paternity case where the parties are unable to reach an agreement on all of the issues before the resolution management conference, each side must provide certain documents and information to the other side. For example, in a divorce case, you may have to provide statements from bank accounts, credit card accounts and retirement accounts, copies of tax returns and insurance policies, and lists of any real or personal property you own. You have to provide this information to the other side within 40 days after the response to the petition was filed. You also have an ongoing duty to disclose, so if you come across new or additional information that you haven't given to the other side, you have to disclose it within 30 days of receiving it. If you do not give the other side the information and documentation that you are required to give them, the court can and probably will sanction you. For example, the court may order that at trial you are not allowed to use any information or documentation you did not submit to the other party. The court can also order you to pay the other side's attorney's fees. At the resolution management conference, the judge will enter on the record any agreements you have reached, and those will become binding agreements. The judge may also work with you to see if you can reach agreements on any of the other issues. The judge is not allowed to decide or rule on disputed issues at this hearing. Rather, what the judge will do is set those issues for a trial or evidentiary hearing. So you shouldn't use your time at the resolution management conference explaining to the judge why he or she should agree with you or why the other side is wrong. Instead, use this time to try to come to an agreement on any outstanding issues. The issues that the parties cannot agree on at the resolution management conference are set for trial or an evidentiary hearing. Typically, at the resolution management conference, the judge will ask you how long it will take you to gather up all of the information you want to present at the trial. If you tell the judge it will take you 2 months, then the judge will either set a status conference in about 2 months to see if you are ready for trial and set a trial date at the status conference, or the court will just give you a trial date that is about 2 to 3 months out. The judge may order you to participate in services during the time between the resolution management conference and the trial date. For example, the judge may order that the parties and the children participate in a parenting conference. At that conference, the parenting conference officer who conducts the conference may meet with you and the other parent to gather information about how you will make major decisions for your children, how much time each of you will spend with your children, and that officer may also talk with your children. The officer will then write a report, including the information, and will provide the report to the parties and the judge. The judge may also order that you participate in a family evaluation or some type of mental health service, such as a psychological evaluation. All these services need to be completed prior to the trial or evidentiary hearing. Another type of hearing that frequently occurs before the trial is a temporary orders hearing. If a party files a motion seeking temporary orders, the court must hold an evidentiary hearing on that motion within 60 days. The motion for temporary orders can be filed with or after the petition for dissolution or the petition for paternity. Things that can be asked for in temporary orders include who will live in the marital residence while the divorce is pending, who is going to pay the bills for the family residence while the divorce is pending, what parenting time the parties will have, what type of legal decision-making that the parties will have, whether either side is entitled to spousal maintenance, and if so, how much and who will pay child support, and how much child support will be paid each month. These orders, although only temporary, will typically stay in place until the final divorce decree or order of paternity is issued by the court. The court usually holds a preliminary hearing within 30 days of the filing of the motion for temporary orders. At that hearing, the court will talk with the parties to see if they can reach agreements on the temporary orders that are being requested. If the parties can reach agreements, those agreements will be entered on the record. If they can't reach agreements on some or all of the issues, the court will set an evidentiary hearing which will be held within 30 days of the preliminary hearing. At that hearing, the court will listen to the evidence presented by the parties and review any exhibits admitted into evidence. The court will then enter the temporary orders that the court believes are in the children's best interest or that the parties are entitled to as a matter of law. A party can ask for temporary orders without notice, which means a party can come to court and ask the court to enter temporary orders without letting the other side know what is going on. While a party can ask for temporary orders without notice, courts rarely grant these requests. In fact, in order for a court to grant a request for temporary orders without notice, the court has to find that unless the request is granted, irreparable injury will happen to either the person asking for the temporary orders, that person's property, or that person's child. These should only be asked for and will only be granted in true emergency situations. A judge will rule on a request for temporary orders without notice immediately upon receiving it, based solely on what is written in the motion, without speaking to the party who is asking for the temporary orders without notice. If you truly have an emergency situation where irreparable harm will occur if the court does not act immediately, make sure that everything you want to say to the judge is written down in your motion. If the court grants a request for temporary orders without notice, the court must hold a hearing within 10 days. The party who asked for the temporary orders without notice will then have to serve the other side with that request, the court's order granting the request, and the date and time for the hearing. Because the hearing has to happen within 10 days of the court granting the request for temporary orders without notice, this service must occur very quickly. The court will typically tell you the date by which you have to complete this service. At the hearing that is held, the court will hear from both sides and, after doing so, decide whether to keep the temporary orders in place.